I mean, good evening, everyone. I think I should give a background of how this particular seminar came about. It happened in one of the matters. There was a judgment of mine which got circulated, and the set of discussion happened in the group. Then me and Ravi had a chat, and Ravi suggested that we should have a discussion on set off. It's a good topic, and that is how this came about. So first, what I'll do is I'll just read the relevant paragraph of the judgment from where it started, so that the background is known. Just a moment. I'll share the screen.
Yes.
Yeah.
Yes.
Fine. Now, this is the judgment which was the starting point of this particular seminar. What the situation was like this, that the income tax department adjusted the refund during CIRP. Now, the NCLT took a view that the CIRP period is over, and before the liquidation order in the interim, it has been adjusted. So after the CIRP period is over, then it can be adjusted, and they also talked about 52 security interest being available. That is the starting point of this particular thing, where we pointed out to the NCLAT that the moratorium is there till the liquidation order is passed, and 52 kicks off only after the liquidation order. So obviously, this particular judgment is incorrect. So in the judgment, since it was a refund which has been set off, the NCLAT also dealt with the set off part of the judgment, under what circumstances. But in January, a Supreme Court judgment had come on this issue, saying they dealt with that. Very briefly, this is what this judgment said. So it said that at this juncture, we may refer to the judgment of the Honorable Apex Court in Bharati Airtel was Vijay Kumar, wherein after explaining the contours and different meanings that can be ascribed to the term set off, it was held that set off done at the behest of any entity against the company while undergoing CRP is violative of the basic principles and provisions of IBC. The relevant exceptions of such judgment is as under. Okay. Now they're talking about 5 different kinds of set off: the statutory or legal set off, the common law set off, the equitable set off, the contractual set off, and the insolvency set off. Right? Then after dealing with that, they explain briefly. So, now at the outset, we should record that there is a difference between the corporate insolvency resolution and the liquidation process of IBC. The corporate insolvency resolution process focuses on and fosters rehabilitation, revival, and resolution of the corporate debtor, whereas the liquidation process focuses on the constellation of the assets of the company in liquidation and distribution and payment to the creditors from the liquidation estate in terms of the order of preference set out in the insolvency statute. Unlike, this is a very important paragraph, unlike the provisions of the Companies Act 1956 or the Companies Act 2013, IBC in the case of corporate insolvency resolution process does not give the indebted creditors the right to set off against the corporate debtor. The early enactments, the Companies Act 1956 by Section 529 and the Companies Act 2013 by Section 325, now omitted, did permit set off per the Provisional Insolvency Act 1920, which enactment is now repealed. Accordingly, under the Companies Act, in terms of the provisions of Section 46 of the Provincial Insolvency Act 1920, indebted creditors a right to set off against the corporate debtor was statutorily recognized, subject to satisfaction of certain conditions. Significantly, in the case of partnership and individual bankruptcies, Section 173 of the IBC permits set off. Regulation 29 of the IBC, liquidation process regulations, provides for mutual credits and set off, which and reads, I'm not reading it. So the title of the liquidation regulation states that they shall apply to the process under Chapter 3 of Part 2 of IBC. In other words, the liquidation regulations are not applicable to Chapter 2, Part 2 of the IBC, which relates to CIRP. Again, they have referred to Section 36(4) as what will form a part of the liquidation estate and which could be subject to set off in that. So, very clearly says when an asset is excluded from the liquidation estate, it is not available for distribution in the liquidation process. it follows that if a creditor exercises an allowed set off in terms of section 36(4) of the IBC, this creditor is given a preferred status over others, including secured creditors, to the extent of the set off. Now, they have also referred to section 238 of the IBC to come to the conclusion that chapter 2, part 2 of the IBC, the provisions of IBC and CIRP do not recognize the principles of insolvency set off, nor can insolvency set off, which is contemplated in regulation 29 of the liquidation process regulation, to be applied to CIRP. So now they are very clearly saying that since when it is a settled law that regulation 29 of the liquidation process regulation does not apply to part 2 of IBC, we have no hesitation in holding that regulation 29 comes into play only after liquidation order is passed by the adjudicating authority and not at any moment earlier than that. Given this position, we hold that the adjudicating authority committed grave error to hold the moratorium had come to a halt during the period of vacuum from the expiry of the CIRP period till passing the liquidation order, and that the respondent was entitled to conduct the set-off exercise and to realize the security interest in terms of section 52 of the IBC. So this is briefly the position in which it started. Now I'll stop sharing this. Now I will go to the PowerPoint presentation that I have done, a very brief presentation. So now is it visible? Fine.
Yes, yes.
So now what is the issue that was there for consideration here is that the present appeals raise a question on the right to claim set off in the corporate insolvency resolution process when the resolution professional proceeds in terms of clause A to subsection 2 of section 25 of the insolvency resolution IBC to take custody and control of all the assets and liabilities. This is precisely what was decided. Now they had talked about what are the kinds of set off that has been talked about in the judgment very briefly. Talked about statutory or legal set off. Now this comes from the CPC Order 8 Rule 6, which provides for set off. And 6A talks about counterclaim, so that the defendants therein can present their case and say, fine, you are asking for this, but I have to recover so much, then the matter can be decided. So that is where the statutory or legal set off is provided. Now the equitable set off, which is of course the ground of the principle of fairness and justice. Now, there the adjustment of claim in a manner that reflects the true nature of the parties' dealings. So the nature of the parties' dealings will be looked into very keenly before allowing such a set off. So what is the why it will be allowed? It will be allowed only there is fairness and efficiency in legal proceedings. So what is very important equitable set off? The principle of fairness is very important. So this will provide efficiency to legal proceedings. So claims and counterclaims which are closely related will be resolved. Very important. It has to be closely related. Otherwise, it doesn't make sense. Now, the contractual set off. Now, the benefit of a contractual set off is gives freedom to contract and autonomy and efficiency in financial dealings based on mutual agreement between the parties. Of course, they have to be legal within the four corners of the law, and public policy is the requirement for a contractual set off. Very, very briefly, because if that freedom is not there, then very difficult to enter into contract, because tomorrow you fear that what could happen. That also has been addressed later. We'll see that. Now, insolvency set off is applicable during liquidation, involve mutual debts or dealings on LCD. Thus, debts are efficiently managed during liquidation of assets, thus recognizing the interconnected nature of financial relationship. Now, let us look at the set off in CIRP and liquidation as per the judgment. So, when we look at CIRP, we look at resolution. In liquidation, the focus is distribution of assets. So, the Supreme Court says that there cannot be any set off of debts against the corporate debtor during CIRP. Of course, under section 173 is allowed in partnership and individual bankruptcies. So the distinction has been primarily made based on the objectives of CIRP and liquidation. So, what is the logic of prohibiting set-off during CIRP? Is the CIRP, the whole motto is to preserve the assets to maximize the value than favoring X or Y creditor in any individual creditor. So now, under section 36, subsection 4, the board can specify assets subject to set-off on account of mutual dealings. So there, the creditors are given a preferred status to the extent of the set-off value. So, being a recovery mechanism, the mutual dealings are adequately recognized and addressed. That is the logic behind allowing that. Now, the pari passu principle. Now, the whole insolvency process, if you look at the entire scheme of the code, the pari passu principle is what is important. That is what gives confidence to the creditors. So they are treated equally at every stage, right? Now, a set-off definitely will result in that particular pari passu principle being violated to an extent. So now let us look at that. That is very important. So what happens when set-off is done? Whatever is asset available for distribution is reduced, and it gives an unfair advantage to a particular creditor. So this is very clear if you look at section 52 and 53 of the code, where the hierarchy is set up and also the methods in which it can be done is very clearly laid out. So if you see the whole scheme, fairness and equal treatment are the principles that is very important in an insolvency process. Now this balance is disrupted if you permit set-off. So set-off is permitted only if it is explicitly mandated or legally justified. So to ensure that the integrity of the equal distribution processes framework is preserved. So it has to be achieved without undermining the insolvency law. That is what Supreme Court is saying. Now, mutual dealings require shared identities between parties, allowing mutuality despite separate transactions. So this is not allowed in CR. Now, what is the exception to the set-off rule? Now, they are saying the Supreme Court has a contractual set-off. So now, the sanctity of a contract entered into prior to the commencement of the CIRP has been, recognized by the courts. Now, SC has explicitly said that any contract prior to CIRP, if there is a provision for a mutual set-off, then that has to be recognized. So this gives the flexibility and the freedom to the parties contracting without the hanging sort of moratorium on commitment of CIRP. The other set-off which Supreme Court talks about, the equitable set-off. So here they are talking about claims and counterclaims which are interconnected and closely related are permitted to be set off. Now, very important thing it says through one or more transactions, provided the claim is quantifiable and purely monetary. This enables resolution of related claims, promoting fairness and efficiency. So this is carefully circumscribed to ensure that it does not undermine the broader principles of insolvency. So, 2-3 observations based on the broad principles that has been enunciated by the Supreme Court. This clarified that statutory set-off are impermissible under CIRP. It reinforces the pari passu principle. It says it is sacrosanct, but there could be exceptions. Framework for understanding and applying set-off has been created. A balance is created for fairness in debt resolution. So this basically is what I am through. Now the discussion is open for the forum to discuss. And if Ravi has to add something to it, fine.
Hello. I think I will cover the judgment because there are intricacies and
Yeah, I
nuances
agree with you. I
which
only
need to be
gave the preamble
understood.
to the whole thing.
Yeah, I will take that up now.
Yeah.
Okay, the 5 types of set-off, that is what the judgment says. What they are has been broadly covered, except common law set-off. Now, because the judgment itself doesn't cover this, it says it in the 5 types, but it covers it through comments rather than specifically as a paragraph. The common law set-off is because India is also a common law country, like UK and many others. Most of the colonial, British era colonies do follow the common law doctrine. It means that which has come by practice over a period of time. And even the Constitution of India recognizes this by saying custom and usage, which has over time acquired the force of law. So that is common law. So common law, as far as set-off is concerned, is what we do every day. And A owes X money to B and B owes Y money to A. Ultimately, it is netted off and only the balance whoever owes to whom is done. This is normal. This is like practice. And that's why it's called common law. Okay. So, however, the common law set of principles, as per this judgment, reading from the IBC, do not apply under insolvency automatically. In the UK, they apply much more strongly than they do in the UK, in the sense UK insolvency law. The judgment also talks about that. Okay, this was covered. Some of these are basically the highlighted words. I will share the judgment copy where these have been highlighted by me, so you can skip the reading the entire judgment and just read the highlighted portions. Okay, cross obligations is a necessary requirement of legal set-off, and it has to be by statute. So CPC is one example, but any other statute could provide for cross obligations and legal set-off. Okay, equitable set-off is not that which is not prescribed by law, but fairness says that it should be allowed. Otherwise, it will be unfair to one or the other party. So that is again equitable. Equity comes from common law, does not come from statute. Okay, same transaction that is covered. Okay, contractual set-off. Now, contractual set-off is the one which is actually the most common form in business transactions, where it is explicitly mentioned or implied by way of an expression which is there in the contract or by practice. If the practice is that set-off is there between two parties in terms of a contract, irrespective of which transaction and how many, they can set it off. So there was a question in the chat box that sale and purchase transactions between two parties A and B, can they be set off against each other before insolvency? Yes, because that's normal practice as long as they agree. It can be by contract, in which case then post-insolvency also it might carry forward, subject to certain restrictions under insolvency law as interpreted by this judgment. Okay, our insolvency law does not specifically talk about it. So when such an issue comes up, it needs to be looked at. That's what these are all paragraphs from the judgment, more or less verbatim. Okay, what is being put here? The applicability of contractual set-off requires an assessment of the understanding. By whom? By the court or the statutory authority, like the RP or liquidator, who is assessing the claim, whether this is applicable or not. So they talk of court to consider. So when a dispute comes, contractual set-off, the court will look at these factors. Now, insolvency set-off, this is what is largely of interest to us, but also contractual because that Supreme Court has said applies during CIRP 2, is when demands are between the same parties. So this is like that. It has to be between A and B only, the debtor and the creditor, between the two. It can't be involving a third party. Multilateral netting off is a different concept, which is allowed, in CIRP for determining claims, but under certain very specific conditions. And I think those rules are yet not notified when it comes to financial service providers. Commonality of identity. Okay, that's basically it is the same party under the same title in the same status, etc. Now, insolvency set off in with these description covers distinct and independent transactions. Now, this is different from contractual set off, which is said to be only similar type of transaction. This is what the judgment is saying. Once we read that, along with again the definition of, the text of Regulation 29, we will have doubts. This judgment is not clarifying all the doubts. There are gaps in it. There are some inherent contradictions in it. They are there. Like any other first-time judgment, it will be there. It's over a period of time that these gaps get clarified, filled up, corrected, maybe amended. Okay. Here, the mutuality is of parties. Now, if you look at the Regulation 29, it's talking of dealings. Supreme Court is saying parties. So, does it mean the same thing? Or does it mean different? Okay, food for thought. Now, the Supreme Court is saying mutual dealings are not so much concerned with the nature of the claims, but with the relationship. So, A, selling cars to B and buying horses in return or whatever, you can set it off is what this interpretation means. The pure text of Regulation 29 tends to mean something different. It seems to focus on the transaction. And in this judgment, the previous paragraphs do tend to indicate that the transaction is important, the connection between transactions, similar nature. Now, suddenly it says that's not important, it's the identity, as long as it is between A and B. Okay. And then we will see if the identity is this issue, then is Kota Kurja right? Okay. And the basis is that asking that party, any one of this, whichever is the aggrieved one, to go to another forum to recover its part of the claim would be unfair, unjust, and without regard to the other. Okay, nice thing, good. But like Rainbow did, this might open a Pandora's box. At least in Rainbow, the law was pretty clear to most people. And then the part about the last one was treated as obiter dicta largely. Here it is not. It is part of the reasoning of the judgment. It is the body of the judgment. Now, talking of, it refers to this, Devarajan mentioned this, reference to Companies Act is actually irrelevant. Because Companies Act is not about restructuring. It's about winding up, which is the same as liquidation. So, set off being allowed in liquidation, it was then, it is now. So, really speaking, this para has no relevance to any of the conclusions in the judgment. In fact, it could be even misleading. It is information, yes, but the logical thought which tries to develop from this is not exactly gelling with what follows. Now, this is okay, where there are mutual dealings. Now, dealings is, dealings between any two parties are always mutual between the two. So that's not rocket science. Usually that term would mean similar type of dealings. But as we just saw, the judgment says, no, it doesn't need to be the same type. It could be different. But as long as it is between A and B, which means the corporate debtor and its creditor. Okay. This is another argument which has been used, that liquidation regulations are in Chapter 2, Part 2, hence they do not apply to CIRP. Fair enough. Where is Section 12A? How come it is getting applied in liquidation? if this is taken as sacrosanct laying down of the law, then under Article 141, all 12A applications under liquidation cannot be entertained. Just thought. Okay, now this para is again important. Set off of the dues payable by the CD, that is, okay, for a period prior to the commencement of insolvency, fine, cannot be made and is not permitted in law from the dues payable to the CD post the commencement. Now, is this something new? And what is the meaning of the word payable post commencement? Is it the day on which that payment arises? Chirag, we'll cover. Just note down and we'll cover all that. Otherwise, the thread will be lost. So, is it about the actual payment or the date on which the payment falls due? What is to be understood from here? Because somebody delays the payment, you cross that threshold, or you do it earlier and you escape that. So is that what is meant? So as I said, there are lots of question marks and a lot of work for lawyers. Okay. Now, this is a paragraph I put in red simply because I couldn't understand it. Okay. So, a debtor cannot, after notice of assignment of his debt by the creditor, this is about debts being assigned, okay, by creditors. That's allowed. Okay. Improve his position as regards set off. Now, the debtor, okay, by acquiring debts incurred by the assigner, the original creditor, which are payable to a third party. That means I, as an insolvent company, go on and acquire debts which are owed by my creditor to somebody else and then use it to do set off. Now, this whole paragraph, again, what is the relevance? Because no insolvent company is ever allowed to do any of these activities. Once it is under insolvency, which means there is an RP in place or a liquidator in place, there is no question of buying somebody else's debt.
Ravi,
So,
is
yeah, hold on, Rekha. I'm just,
sure. Okay.
Yeah, just note kar lena. Just trying to raise as many questions once and then we will do it open. So that's why I'm confused. So I put it in red. I am not able to understand this. Okay. Okay, doctrine of pari passu covered, grants covered, section 53, 52, read with that. They uphold the pari passu principle covered. Okay. This again is what they say. Statutory set off is not applicable during CIRP. Fine. With two exceptions. Now, what are these exceptions? This contractual set off is okay. Very important exception that contractual set off can be put into force in CIRP. Moratorium is fine, but contractual set off, in fact, does not act. It said that it is not in conflict with the moratorium. It's an exception carved out of that. That contractual set off can coexist along with the moratorium principle. Now, this has a lot of implications because till today, almost all of us were saying, what you have to give to me, you have to give to me. No questions. What I have to give to you, you file a claim. Even though it might both be related to a period prior to commencement of insolvency. And suppose we do have some contract. As it said, the contract doesn't have to be expressed, but by indication. Then, have we been violating this principle all along? We means the whole system. Now, there is a reasoning behind it. Debtor's title to sue is impeached. Impeached means that it is adversely affected, challenged, etc. We don't use such English normally. That's why it's a bit difficult to understand. So I did have to Google search to understand what it's meant. Okay. But the last line, the RP takes the debtor's property, which means the assets, subject to all clocks and fetters affecting it in the hands of the debtor. That means, except those which are prohibited, let's say by moratorium or any other express provision of IBC, all previous rights, but more importantly, obligations continue. Okay. So question asked was 238. 238 is a non-obstant section which is there in every single act enacted probably in the last 40 years or 50 years. In fact, a similar clause in the Companies Act would probably come about 30 or 40 times within the same act. So 238 is the principle of last resort when everything else fails and no harmonious construction or is possible between two conflicting provisions of the same law or different laws. Then you use 238 to see, and there are principles of 238. Central versus over state, earlier versus later, special versus general, all that to be applied. So 238 is not the first choice to be used for anything. Okay, equitable set-off. Now, this is the Pandora's box. What is equitable set-off? It's not, it's beyond what is defined. That which is fair, just, transparent, blah, blah, blah. Who decides? Okay, question. Amount to be adjusted should be quantifiable and unquestionable monetary claim, money for money. Now, just though it's not directly there, but in a way it is related to set off with the provision of, I think it's in the regulations now, that in real estate insolvency, when a possession has been taken by an allottee, but let's assume all the other things are not complete, then would this apply there? Because that's not money for money. But not to be included in liquidation estate, does it fall foul of this explanation? Or is it something special? All are points for litigation and thought, nothing more. Now, this says it does not require legal proceedings. Again, a very dangerous precedent. When it doesn't require legal, it means whoever is the one to decide can decide, which in our case would mean the RP or liquidator, whether it is applicable or not applicable. Okay, I'm now rushing through. Okay. So chapter 2, part 2 of IBC does not recognize insolvency set-off, but it recognizes contractual set-off and equitable set-off. Okay, again, something which I was confused, so I've just put it in red. I don't know what this means. It's there. These are picked up from the judgment. It talks of the UNCITRAL guide does distinguish between set-off obligations maturing prior to commencement. Prior to commencement, why would it be a problem? It's normal. And then afterwards. So what does it mean by saying set-off obligation maturing afterwards? Can't understand. Okay, then this is of course the example. That's why it is included here. In this case, the Supreme Court allowed set-off in relation to interconnect charges, okay, between parties, because they said it's common practice that different service providers, when there is call between them, there is a charge for each receiving or sending whatever, and overall it gets settled, and this is a common practice. It is there in the contract, the interconnect agreement which they sign with each other. So that's allowed. But set off against the other part, which was the, I think, related to spectrum, the bank guarantee encashment, etc. That being a separate, unique, totally different transaction, not connected with this, and no contract was there about that. So that's not allowed. So this is the judgment. And now, floor open. Yes, now we can start questions.
I think, Ravi, those highlighted points where you had issues, one by one, if you take up, then the questions will come.
In my opinion, they're not very important. They are
Yeah.
really good for lawyers to litigate. So that's why I just highlighted it. I will share the PPT.
So otherwise, what will happen is that in this forum, people will look at those cases where they have practically faced a problem and what they have done.
Yeah, that's better. No,
That's how it will happen.
let's discuss
Yeah.
that way. I will share that PPT in our group. Okay.
Ravi.
Huh.
So, I had put in the chat box that there is a purchase and sale transaction with a party.
So we talked about it.
So what is the conclusion?
No, we talked about it. Did you listen?
I listened. But my query remains, is it an equitable set-off or not?
No, it depends on how it is done. See, if it was done by practice prior to insolvency, that there are transactions between two parties, same two parties, A and B.
Yeah.
And they are of different nature. Okay, A is selling some goods to B and buying in turn either goods or services which are different.
Right.
And are they subject to set off? If the prior conduct of parties indicates that they have always, even though there is no written agreement of set off, that they have followed the principle of set off, then it would imply that it was there as a part of the agreement between the parties, and it will apply.
So in that case, the Bharti judgment.
But for any reason, and it could be any number of other reasons, nothing to do with IBC, that A buys item X from B, pays for it separately as and when it matures, and buys item Y from B. And again, when it buys, it pays, and when it sells, it gets paid. And these two are kept separate transactions, as if they are separate contracts. Then set off will not apply.
So in that, then I have a problem. In this Bharti judgment, if you see, interconnected charges were always set off prior to, as a matter of conduct.
So they allowed it in the CIRP. Supreme Court allowed interconnect charges. They said that's okay. That was rightly allowed. The set off for the bank guarantee encashment given by Bharti Airtel to Aircel entities for bidding for spectrum, that which devolved, that they said no, that is not allowed to be set off. You claim that separately.
So interconnect charges were allowed, right?
Yeah. That's what I just said.
Okay.
And one more thing here is that if the parties, even the separate transaction, which just now Ravi pointed out, that you buy X goods and Y goods separately, maintain separately. If there has been a practice of setting it off as a precedent, then it will be allowed because that's how the contract is working. Though it may be different in nature.
It might be, but if the practice is such that it is treated as a composite agreement between parties, I keep buying so many things from you, you keep buying so many things from me, and this thing happens between traders who deal with different commodities, like retailers and wholesalers. They don't trade in everything, so they have a customer who requires something which they don't have. They will take it from somebody else, and that fellow in turn will take something which this fellow has on that day. And this keeps going. They net it off. As a practice, they do all the plus minus and net it off. So that is, by practice, set off has been accepted between the parties as a principle. But let's say if you are talking of two multinationals or large corporate companies, okay, even large corporate, and if they have dealings between A and B, two large corporates, they will never set it off. Because they will have different terms for each one, detailed purchase order, everything will be separate. They will say, "Mere ko jo dena hai, main mera check alag se bhejunga. Whatever you owe me, you pay me separately." That will never be considered as set off.
See, the first slide where you had marked the red color, no? I think
red वाला एक मिनट दिखाऊं क्या?
When you were reading the prima facie, probably I understood that is it something it is talking about a garnishee order?
Talking about
Garnishing, garnishing,
Balance sheet.
garnishing.
Garnishing order.
Oh, garnishing. No, let me just come to that and try to remember what it was. Ek minute, huh? Yeah. No, the first one was about assignment. This is a very peculiar example that is given that here is an insolvent company. Okay. It has got its creditor who has probably filed claim and then assigned it to somebody else. And then this insolvent company, to take advantage of this set of principle, goes and acquires debts of the creditor. Okay, the debts owed by the creditor to a third party. Acquires it and then uses it to say, now I set off, I don't owe you anything.
But how can the insolvent company during
Exactly.
CIRP
That's why I
acquire?
said this question mark. I mean, this is what I understood from the text
But,
of.
I mean, are we interpreting incorrectly that sentence?
The first thing I said, I don't understand this, but this is why limited understanding.
Will you just put up that slide once? We can read it again.
Abhi karta hu.
We'll read it again.
See, my honest opinion is something went wrong in lost in translation ho gaya hai.
See, such a position can happen prior to CIRP. It cannot happen during CIRP, right?
Exactly. And
So
what
are they referring to
prior,
a situation prior to CIRP? If
but
it is
then
done,
how-
then it will not be eligible for set off.
maybe, but it should have been clarified. As I said,
Yeah,
it
I agree with you.
wrong.
I mean,
It might
otherwise
be
it doesn't
missing
make
a
sense.
couple of words which they are trying to say ki don't try to do funny things before CIRP just for
Yes.
undermining your liability.
If that is not the interpretation, this sentence doesn't make sense.
Yes. But they took, okay, this is one thing. It would also probably be subject to section 65, 65 or 66.
Because the last sentence
65,
tells
66.
me that it could be, because it says this will be contrary to equity and would amount to misuse of the provisions of insolvency.
तो insolvency हुआ नहीं है तो
Yeah, ठीक है.
getting prepared for insolvency does happen. It's not. It's very common in the US. People do all this sort of things prior to insolvency.
So avoidance transaction will लेना पड़ेगा इसको, if it happens.
Whether it could be that. And the other one was something different. That was
Ganti sir, when you hear the referring the debtor, does it not necessarily that corporate debtor, maybe a debtor who owes to something to a corporate debtor?
we can't make that assumption when they are
Yes.
talking of insolvency. Debtor should mean corporate debtor because everybody is a debtor to somebody else. See, what does it say? A debtor cannot, after notice of assignment, improve his position. I mean, it can be. Or does it mean a creditor?
It means, see, if I read something about that, because if you look at that particular aspect, in the CIRP can't be have a acceptance such kind of connotation what put up by this in judgment. But I am looking in a different way about that. If some debtor who owes something, who has to pay something to corporate debtor, okay, and he has acquired.
Then we will call him creditor, okay? Because let's not
let him call,
Yeah.
creditor.
So a creditor of the CD then does what? Now it says.
Now the creditor will have notice of assignment.
No,
The
he has assigned his receivable, right?
Yes.
So he has ceased to be a creditor.
Correct.
So does he have any interest in acquiring?
Something what is saying that like if corporate debtor something wants to recover something from his debtor, but after assignment that debtor become a creditor for that corporate debtor, and he said my position has improved, I don't want to pay something to you. That is what is something they're saying.
See how a creditor, why would it become a debtor? Creditor will remain creditor. Okay. There is only one debtor in insolvency.
I mean to say about that. If some like I'll give you example about that. Some like there are two kind of situation which arise about that. Suppose A is a corporate debtor, okay, and he wants to recover something money, showing in the balance sheet from the X. He's payable, but X is acquire some debt, what you call the debt, which is payable to the Bank of India, and Bank of India debt is pass on to this particular debtor. And he now, after he that individually mutually set off that I owe this corporate debtor 20 rupees, but then I acquire some creditor, okay, of that particular corporate debtor, like Bank of India debt. Now 30 rupees there, where the Bank of India has to recover from corporate debtor 30 rupees, and I have to pay net 20 rupees. So 10 rupees is doing the adjustment about that. That is what they're talking about that. So it's a transaction between the debtor and creditor, which is not a corporate debtor, which is showing in the books of account.
No,
they are
what is the
doing
meaning of the term notice of assignment? Then all that, see that what you are saying is tripartite. So,
yeah, because they are doing
multiple party transactions, which has been clarified earlier that it can't be. It has to be between the same two parties. So that tripartite anyway cannot be done. So this one is talking something else. The meaning assigned, which Devarajan interpretation, I think is correct. Some words are missing here. Okay. Typing mistake hota hi hai. So maybe over a period it will get clarified. If that logic makes sense, that you can't do these sort of things just to wiggle out of or rather change your position in insolvency. वो हो सकता है. But this three-part transaction is not covered here at all. Now, this is about the UNCITRAL guide. Here, the marking was because I thought this was obvious, but unless they had something else in mind, which is not clear. See, UNCITRAL guide talks of set of obligations maturing prior to the commencement of the insolvency. Maturing, okay. Nothing to do about payment, that the obligations have matured. And set of obligations after the commencement. So, does it mean, possibly this is what it means, that between A and B, certain transactions are matured prior, payable, receivable. Something is maturing afterwards. That the transaction which matures, which was or could have been set off earlier, now because it has matured post CIRP or post commencement of insolvency, can it still be set off?
No, if we read this judgment, I think it's saying no, because if crystallization after the CIRP, they say simply no.
It says that. And I'm not saying that. That is obvious from the next sentence.
It has two words. While the latter should be disallowed or allowed to a limit next. So there's the or also there.
No, that is the allowing.
Yeah.
No, my confusion was that what is this maturing business? Because see, litigation
maturing means due here, I think, Ravi.
No, litigation will not happen on what is allowed and disallowed, because that part is clear. All the litigation will be on defining what is maturing. And if every lawyer will define it differently and try to put that.
No, maturing will be, in very simply put, it will be due. If it is due and payable, then it can be set off. Otherwise, no.
But then claims which are not payable on insolvency commencement date are also claims.
I agree with you, but there is nothing to set off. That set off may be maturing during CIRP, so you cannot set it off.
No, see, A owes money to B, B owes money to A. A is the CD.
Yes.
Okay. On insolvency commencement date, some of these transactions have matured for a payment, some have not.
Yes.
Okay. But both are claims on each other.
Agreed.
So which one will this be? This will all become...
No, suppose you look at it from the point of view of a creditor. For the creditor, whatever is matured and not paid, but not matured and due later will form a part of the claim if it is outstanding in his books. Point
Exactly.
number one.
Yes.
Now, as far as setting off is concerned, if it becomes due and payable, that is what I think they mean by matured. Then, if it happens before CIRP, you can set it off. But suppose, post the CIRP, anything as far as the creditor is concerned is matured during CIRP, that cannot be set off. Though the debtor has no obligation to pay what is matured.
Right. Right. And that seems logical.
Yes.
But if this is contractual set off, they are saying it is allowed. Even this
that is post CIRP, no, prior to CIRP, yes.
No, see, that is, if you read the whole judgment, that is not clear.
Yeah, I agree. No, yes, you are right. Judgment says that contractual
does it
set
say
off.
but they are saying that set of obligations will continue. Everything is with all fetters and clocks. So this judgment has got at least 20 paragraphs, which can keep 20 lawyers busy for 20 years.
Yeah, you are right, because contractual setup will create conflict with this particular provision. Because reason is that in contract you can have some dues going to mature during the CIP. Contract is there in existence about that, because sometimes we say that after 90 days you have to pay something and 90 days falls within the CIP. Then what will do in that case?
It can. So
Technically, Deepak, I would say that those things will be pertaining to keeping the CD as a going concern, where there is the operational credit as an arrangement in terms of buying and selling to the same party. That will continue, could be one of the possibilities.
yeah, I mean, it will ultimately, what will be, it will be lot of judgmental issues will come. And where judgment of the RP or liquidator comes into play, litigation follows soon thereafter.
RP has no judgment. He has only collate.
नहीं, ये decide कौन करेगा? Set of खाए कि नहीं? वो तो every time you can't go to NCLT unless they say
You
that
take an
all
opinion
set of decisions.
as you rightly said.
So
Sir, now IBC cases will also become a civil litigation cases now and going forward with the coming of such kind of precedent.
So this judgment clarifies a lot of things, but at the same time, like any first judgment on the subject, it also raises questions, which hopefully will get settled over.
I'll tell you the problem where it is that, it started is because, in CIRP, in the form that you fill in, there is a set off provided. Whereas the regulation and the act doesn't provide. So that itself is a starting point of confusion for many.
Yes.
I think, can I ask you one thing?
Haji.
Suppose a bank guarantee was given against a margin money. And that bank guarantee is claimed during the period of CIRP. That means the CIRP is started, and after that, somebody has claimed under that guarantee.
Yeah.
Now, can the bank set off against that margin money?
Yes, there is a judgment to it, yes.
There are multiple orders and judgments on that. And the logic behind it is like this, that it is not a liability being taken by the bank. It is only a means of, or rather it is acting for you as an agent. In that particular bank guarantee, which is against margin, to the extent of the margin, the bank is only an agent of the corporate debtor. And it is a creditor, only contingent creditor for the rest of it. So 100% margin, it will be 100% agent only. That is the interpretation. That's why they say nothing wrong with it. It can go on.
So margin will be adjusted. The balance will become part of the claim.
Yes. And that is because in a way it is contractual set off. It is written in the contract of guarantee that the borrower executes with the bank.
No, but just now, Ravi, you have said that in IBC, the asset has got to be maximized. So my asset is asset. You have to take
one second.
Then you take
a clarification on this. The guarantee is invoked by a third party on the bank, not on the borrower. The borrower's liability effectively is zero when he gives 100% margin and takes a BG. Okay. So उसी दिन हो गया है वो.
And if he has not given 100% margin, say 25% margin.
To the extent of the percentage margin that he has given, that is like a prepaid instrument.
But you have said just now, I'm going on your word.
I'm not. See, what I
have said that my asset is my asset and liability you claim.
No, suniye. The asset of the, in the book, margin money has been held to be an asset on lien, which can be forfeited by the bank even during sale. That's the judgment. Okay. These are the judgments. So law is what? Law is not about what is right. It is about what is allowed.
How it is shaped.
Okay. So like a very eminent, lawyer once said, and which I wholeheartedly agree with, he said the Supreme Court is not...
So you please modify your sentence, saying that my asset...
What is my which sentence of mine?
Except those where...
from beginning, I'm telling disclaimer, there are good points here, bad points here, doubts here, cracks here, all that. So take it with that. No, I'm not sitting here on judgment. I'm just giving what is a first cut understanding, nothing more. There are lots of questions here. There are lots of ifs and buts. But broadly, the situation is better than what it was before the judgment. It's a step forward, no doubt about that. It's a big step forward. There will be questions. जब आएंगे तो handle हो जाएगा. Now coming to the order or judgment which was the genesis for this discussion today, and that is the Kota Gurja. Now in there, now look at this. There was no recovery. Okay. There was no taking or giving of money. There was a liability against one transaction, and there was a asset against another transaction. Okay. I'm talking from the angle of the income tax department. So they had to recover something for a particular assessment year, and they had to pay something as refund for another assessment year. Okay. Now they didn't do anything. The RP or whatever may not have even recovered that money or even asked for it to be recovered. Maybe, I think it got stuck in litigation, so nothing happened. Now the judgment says that if you had waited another 15 days to intimate about the set-off, which is effectively what it was, it is okay. Now during this, that is not okay. Now this is what we have also been, most of us have been following this, that refund is payable to the CD is not to be adjusted for any liability of the CD to the department. That is the stand taken. It has been held consistently in many, many cases, not just one, many. It keeps litigating. The same thing is true for GST also, equally true. GST refunds also similar. But it gets litigated. Now, an entry, is it a recovery? Or recovery has to be something more. Now, this is also answered in another, Mumbai NCLT avoidance transaction judgment in the case of precision containers, where they have held that entry in the books is equal to recovery and cannot be done.
No, but here, Ravi, statutory set-off is not permitted. That's how it goes. Nothing to do with whether entry or no entry.
No, see.
Statutory set-off is...
No, I will counter this slightly by saying it is the common practice of income tax department for decades.
I agree with you.
It has been accepted by the whole...
After giving a notice.
Notice is fine. Notice is only to ensure that it is correct. It is not whether I can. It is not permission. It is... Notice is only to ensure the correctness of the action. Correctness in terms of numbers.
You can contend the notice under 2.5.
Huh?
You can raise issues.
You can contest on what grounds? That this number is incorrect, this assessment is incorrect, that only. So that is whether the claim is being contested, not the right to adjust the claim. In all these notices, the assessee gets the right to contest the claim of the department. कि मेरे को इतना आना है, वो बोलेगा नहीं मैं तो अपील में गया हूँ. You can't do that.
It falls within the ambit of maturing after the commencement of CIRP.
So see, maturing means that is the point. If you owe money to the tax department, it has matured on the 31st of March of that year.
Agreed.
What is done is calculation after that, not maturity, because you are supposed to pay all your taxes by 31st March. Huh? And whatever excess, another 7 days.
No, there is a small correction here. Whatever I have assessed and paid as according to me is matured, is matured. But the rest matures the rest matures only after the assessment.
No.
Please understand. The rest matures after the assessment. That is a law.
A smart cookie will not put anything as zero as assessment and say, nahi hua, nahi. See, advanced tax.
I am not talking of fraud. I am talking of the normal course.
Normal
interpretation.
Agreed. But every payment of whatever, even let us say you keep paying advance tax, something you pay much later. If you pay on your own or otherwise, on your own you get interest you have to pay. if it is beyond the due date. And if you pay after the assessment order, you might even have to pay penalty.
Yes.
So those are beyond the maturity date. The moment an interest or penalty component is applicable, then you are not doing it within the original date.
That is fine. I am talking about the amount I have assessed myself in the self-assessment and have paid, and
Your
then a demand comes in.
is like
That
a
will get crystallized or mature in the day order is passed.
No. Your
That is
self-assessment.
the law.
No. Sorry, sir.
No. The
You are
point is
supposed
that
to pay when the order of assessment comes, and if it finds that you have paid less, are you given interest relief? Can you pay without interest? No.
no, the issue is not
That
of
means
interest.
that
The issue
you
is
did
that
wrong.
I have made an assessment.
They are not penalizing you. They are not putting you behind bars for that, but they are saying pay with interest.
Agreed.
Okay. So वो नहीं है. The date of payment of tax is as per the dates scheduled.
I agree, but the point is in terms of assessment. In the self-assessment,
Anyway,
this is what I say I paid. Now you say you are wrong.
We are here on set off. Okay.
Yeah. So the set off maturity will be the day they pass the order.
That as a lawyer, that your argument is great. But you and I both know it is wrong.
Anyway, so we'll go with the difference and move ahead.
No. Hey, you have to fight like that. Everybody does. Even I will do. But heart of heart, I know it is wrong. Yes. Chirag, where is he missing? He had a question. Chirag doesn't know, he doesn't get CPRs for this.
Chirag Shah is there.
No, his name is there. He is logged in but not present.
See, the interesting aspect, Ravi, is that, now we have different kind of setup we look at when we do avoidance transaction. Debtor के सामने creditor set off कर दिया. Netting off transaction. In the books itself.
Yes. Different parties who have no connection with each other. I know both of them, so I am doing it. That is the only connection.
And nothing on record to suggest that both have agreed. But both are fictitious anyway.
Both are fictitious. So
only note the CD.
So in a way, they are siblings because they are creation of the same parent.
So that will fall within the habit of parties.
But challenging part is equitable setup is going to be very, equitable setup is going to challenge your wisdom, because when we have to interpret multiple times, during the CIP, I don't know, because that will question every time you're.
Everybody will come with that now. कि मेरा तो ये equity है, justice है. See, the way the word maximization of assets has been misused so much. Now equitable set-off will be a close second.
And RP will only take an opinion and decide. And then it will land up in the court eventually.
This judgment gives a lot of work for all those who want to litigate. Yes, we are not getting any questions. Either it's too confusing or too clear. One of the two.
No, I think once you read the judgment in entirety, a lot of questions will pop up.
So let's finish it then.
Yes, maybe most people have left also. I say like that. Are people under the mistaken impression that there are CPRs for this?
No. But I think everyone is listening you and trying to digest. But see,
too heavy.
Yeah, that only.
No, you have actually confused everybody.
I have achieved my objective. I have shared in this chat itself the judgment with the highlighting. So whoever wants to, please download it. You will get that.
Thank you, Mr. Ganti. So shall we close? I think it's 6:15 also.
Ravi, I will request you to share that highlighted judgment on the WhatsApp group, please.
अपना ना रिपा में
हाँ जी, हाँ जी, हाँ जी.
I have put the judgment without the highlighting, just
Yes,
like
yes. I was looking for the highlight part. Yes, sir. I saw, sir. You. Thank you very much. I saw the judgment Airtel one which
Then
you
you
have put.
use Ravi's. Yes, highlighted means
Yes.
it will be easy for you.
Yes, yes. Thank you, sir.
Yeah,
Thank
it's
you.
a
Very insightful session. Thank you.
Okay, can we close?
This is a difficult topic. One reading is must. I think probably thereafter only we have
Reka,
some clarity.
speak louder, Reka.
I'm just saying this topic is bit tough, you know. I mean, one really need to have a really good reading. Then only it will help us to understand that what we discussed today. I mean, you have mentioned that.
So Dipti, it will be a good idea that when all of us read the judgment, you can have one more seminar for clarifying doubts.
The doubts and all that. Yeah.
Devarajan ji, my request is that there are so many setups are there. So if we are just going to read it, we are not going to come out with anything. I think if you go one by one, type of setup and try to find out a question and answer out of that, and one or two examples, probably it will give us better.
No, I think here more important,
covered
Praveen,
all
is
the
that
5.
no, Praveen, more important now is that when practical situations are faced in set off, and people, if any of us have faced such situations, if that is discussed, then it will be interesting.
Yeah.
Yeah, but if you start narrating something like one by one, because there are 5 types of the setup which Ravi
See,
has
as far
highlighted.
as we are concerned, Parveen, there are we need to really look at insolvency set-off, contractual set-off. Equitable set-off is also there. That is going to be the snake in the box. तो उसे जितना हो सके हम दूर रहें, because it's a dangerous thing. Okay. Contractual set-off, you will have the evidence of the contract to take a call when you are admitting a claim. And insolvency set-off also, it's only in liquidation, and there is some degree of explanation given in the judgment, but it is not full. If you go through that, when you go through it, you will find that they are specifically saying, we are not getting into that now, which means that is reserved for another judgment at a later stage. And that is about concerning Regulation 29. Briefly, they have touched upon it, but not in depth, and they have said so in the judgment. So that is, insolvency set-off is the one which is going to be a troublesome affair, because there it is completely allowed. But equally troublesome is contractual set-off. But one thing one can say, contractual set-off, 2 types of evidence. One, that which is expressed in writing between parties. Okay, the other is implied. Now, implied means what? Either by the language of a contract or by the conduct of parties.
True.
Any one of this or both. So, now if you want an example of contractual set-off, now this is my opinion. Devarajan has a different opinion. I'm making it very clear. It's just opinion because nobody knows who is right. Income tax refund and income tax payment. Obviously, it can't be for the same assessment year. It will be for different assessment year. What type of set-off is it? Is it statutory? In a way, yes, because the statute provides for it. The Income Tax Act says that it can be done. Is it contractual? In a way, again, yes, because the relationship in a way, okay, it's not a complete contractual relationship, but there is a concept called statutory contracts, which is different from normal commercial contracts, where one side says this is the contract and the other side just says haji. So the income tax assessment comes in a way under that too. So will it be statutory contractual set-off? Difficult to say. Okay, it falls into both. Which one will apply and which one will not could be a matter of practice. Now, if you go back in practice then, and what has been the conduct of parties, whether it is voluntary or involuntary, but conduct is adjustment of present refund against past liability is always been allowed, and the concept has not been challenged. What is usually challenged is the liability itself, that it is not there. You can't challenge the right of the department to adjust. That is given in the statute. So this is one example. Okay. Easier examples are when two parties are buying almost similar goods. Okay. The best example is from the financial sector, where between banks, they borrow and lend for this Friday netting off every week. Now that is completely contractual setup. They just net off the position, whatever as per
Why
agreement.
daily clearing also is a contractual setup.
Daily clearing is contractual setup.
But one possible reason thinking aloud, since statutory setup is arising out of operation of law, possibly SC says that should be excluded.
Yeah. No, statutory setup, they are
It is
given,
not arising out of the contract part you mentioned.
no,
That may not be the way it is interpreted. The possibility is that all these are basically arising out of operation of law. That is why, if you remember, even in the by an RA tries to put a class, he puts the statutory as a separate class, which is allowed because they are coming out of operation of law, not because of actual any goods or service being provided.
yeah, even 53
So that could be the reason.
separately.
That could be a possible reason.
Yeah.
I think if there are no further questions, we can close.
Shall we close?
Yeah, I think we should close.
Yeah.
Okay, thanks,
Share
friend.
the
Yeah.
PPT, Devarajan ji, and share your Kota Gurja order also in the group.
I'll do that.
Yeah, thank you.
Yeah.
Where you will share, Devarajan ji?
RIPA, WhatsApp.
RIPA WhatsApp, na? Yeah.
The Kota Gurja order is already shared by me in
Anyway,
RIPA group.
I'll put it again now, Sanjeev.
Yeah, share it again.
Okay, thanks
Okay.
everyone.
Thank
At
you,
least
thank you.
everyone has participated actively. Remember, we all are RIPA member to discuss intellectual, all intellectual. Thanks a lot. Thank you, Ravi ji. Thank you, Devarajan ji. Thanks a lot. And you have taken initiative to share your knowledge. That is best.
Thank you, thank you.
There is one more discussion paper, by the way, on valuers, etc. Okay. Again, it's so obvious about it. There is no controversy. So I don't think that's also worth discussing. Let's discuss substantive topics.
Did we discuss
we
on
will,
the real
discuss.
estate DP? DP on real estate, something had come.
अरे
No,
भाई,
couple of-
last time क्या किया हमने इसके पहले?
We did
Discussion.
that, right?
Real estate पहले आया था ना, अभी
Yeah.
आया.
नहीं, पहले.
पहले आया.
किया हमने real estate पे.
Real
Practical
estate
aspect.
हमने किया है, but real estate is going to be a point of discussion for the next 10 years at least. At least.
It's one of the most complex ones.
Yes, complex, sensitive, political aspects है उसमें, social aspect है.
Okay, in RIPA,
आ
our
जाता है तो
group,
एकदम political हो जाता है.
in RIPA group suggests, so along with that, we will discuss this case laws also. Okay, with correct suggestion, whatever clarification. Okay? Okay, thanks.
Okay, bye.
Thank you.
Bye, thank you.